Okay, I think we should begin. I know it's early on a Friday morning, but there's never a good moment, and we are pressed for time. So I'm Philip Alston. I'm part, along with Sally, I'm very proud and happy to say, of the Centre for Human Rights and Global Justice here at the NYU Law School. We're here to celebrate and honour Sally Merry for all of the work that she's done. We're not going to have any long formal speeches. I think one could use a lot of metrics by which to evaluate Sally's career, but I've been warned against relying on such approaches. Nonetheless, I can't help but saying that the number of books, the number of articles, the number of major lectures that she's given, courses and so on, and her impact really are enormous. But she's right that we should stay away from quantitative measures, and that's where qualitative measures come in. And they're both on the professional and the personal, and I'm afraid I insist that the two be put together, particularly in this case. It's funny, with great men, we go out of our way to say, well, we have to separate the personal from the professional. You know, he was a ... but he was a wonderful scholar or whatever. Sally is absolutely a marvellous person at every level, and she is the nicest colleague that I could have worked with. She is one of the most selfless people. If there's any task to be done, she will volunteer for it. She really has been a magnificent colleague. Just a few mechanics. We are going to produce a volume of essays in her honour coming out of this. The deadline for revised chapters will be the end of March. We have enough contributors and enough flexibility that we can actually insist on that deadline, and those chapters that are not in will unfortunately not be able to be included. The presentation today, I'm sorry for the packed agenda. Each and every speaker was chosen by Professor Merry. So that led to a rather significant number of speakers, and we've had to squeeze the program. Apologies. We'll do 15 minutes strictly, and I'm going to have to behave like a sheepdog in order to keep it to the 15 minutes for each person. We don't have chairs for the sessions. We are just going to rely on people to go. We're not going to do introductions. The program is more than sufficiently detailed. Because time is tight, feel free to get up and get a coffee anytime you like. There is a coffee break, but just go and get one. Our final word really is just to say thank you. In particular, well, first of all, of course, to Sally, who has made all of this possible, but we'll be saying that all day long, I hope. To Penelope Fernandez from the Dean's office here. Penelope really is the one who has made this possible. To the Anthropology Department, which has contributed significantly to the costs, and we're very grateful. And to Lauren Stackpool, with whom you will have been in contact, who has done all of the real organising work, and I'm deeply grateful to all of those colleagues. So I will ask Sally just to say a few words of welcome, and then we'll get underway with the panel. Sally. Slowly, carefully.
Well, I'm so honored to have you all here and delighted to see so many people here at the New York crack of dawn. And delighted to have the panel. There's so many people because I produced my wish list of the people I'd like to see come, and I figured probably most of them wouldn't be able to make it. And I'm just so delighted that so many of them have been able to come, and so grateful to the NYU Law School, the Anthropology Department for making this happen, and particularly to the Center for Human Rights and Global Justice, which I've been really pleased to be part of for the last several years, and to Philip Alston for coming up with this idea and organizing it and making it happen. So I think it's really going to be an exciting day, and I'm very pleased and honored, and thank you all for coming, and all of the wonderful speakers for traveling, many of you long distances to be here. So thanks a lot.
Hello, everybody. Since I have only 15 minutes and I'm going to try and stick to it, I'm not going to say too many thank you, but thank you for having me. I changed the title of my presentation yesterday, so the new title is Vernacularization as Epistemic Capture at the Universal Periodic Review. And because I am the first speaker and Jane is going to talk about the Universal Periodic Review as well, I thought I should perhaps explain a little bit this mechanism quickly. As most of you may know, in 2005, the United Nations began a process of reforming its human rights system. The reform was a response to critique according to which the Human Rights Commission had become politicized, and it tended to name and shame certain states while leaving others unscrutinized. And the UPR, the Universal Periodic Review, is this mechanism of human rights monitoring that was established in response to these critiques. So what is it? The Universal Periodic Review is a state-led peer scrutiny by the community of states of the human rights record of each of the 193 UN member states, carried out on a regular cycle of now 4.5 years. It's a full cycle process which comprises 4 stages, which I sketched out here very quickly. So the first stage is the preparation of information for the review. The second stage is the review of the human rights situation of the state under review, which is also called the interactive dialogue, or the working group meeting. It's the 3.5 hours review during which the state under review presents its national report and recommending states ask questions and make recommendations that the state under review is free to accept or to simply note. The third stage is the adoption of the report 24 hours after the review. And the last stage is the implementation of accepted recommendation between 2 reviews. So the review is based on 3 key documents. One document is a national report, which is prepared, of course, by the state under review. The second document is called the compilation of UN documents. It's produced by the OHCHR. It is really a compilation of information coming from the treaty bodies, special procedures, and other UN entities. And the last document is called the summary of other stakeholders' information, and it's a summary that is also produced by the Office of the High Commissioner for Human Rights, and which is a summary of contributions sent by NGOs. So this presentation today is focusing on this last document and on the NGO submission on which it is based. It pays specific attention to the social life of these submissions as they circulate between NGOs' offices in various parts of the world and the OHCHR in Geneva. I highlight the translation work carried out by UN drafters in charge of selecting and summarizing written contribution. And I conceive these actors as intermediaries between the international community of states and NGOs doing a difficult work of translating up the human rights claims coming from the field. I underline the contradictory effects of knowledge practices, forms of expertise, and bureaucratic procedures on the articulation and understanding of social criticism. I want to examine the forms of discipline generated by the bureaucratic modalities of civil society participation. And I want to pay specific attention to the phenomenon of epistemic capture that occurs when OHCHR drafters take ownership of contentious information provided by NGOs. While such process gives this information legitimacy and value within the official discourse, they also distort ideas in a way that reduces their critical content and make them compliant with the dominant paradigm. So the analysis that I present here is really based on the fieldwork I carried out with Jane at the UN between in 2010, 2011. And it's also based on participant observation that I was able to carry out at the Office of the High Commissioner for Human Rights for 3 months between April and June 2011 via an internship, actually. And it's also based on most recent interviews that I was able to carry out in the context of an ethnographic consultancy that was commissioned by the OHCHR itself. So these public reviews, which take place in this magnificent room 20 of Palais des Nations in Geneva, represent somehow the front stage of the UPR, but what we wanted to kind of explore with Jane was also the backstage of the UPR, because it is really where NGOs' participation has been relegated to the backstage, really. Since they cannot really speak up during public reviews, they have devised various strategies in order to get heard. So they are able to lobby states, for instance, in the Serpentine Bar. They're able to organize side events in parallel to each reviews. They are able to send submission to the Office of the High Commissioner for Human Rights, and here it's a team of interns, of which I was part. And they are able to also participate in consultations carried out by state in the process of drafting their national reports. But since their capacity to speak in public is restricted, NGOs' concerns are primarily raised and voiced by others, this to say other states, and the OHCHR via the summary of other stakeholders' recommendations, other stakeholders' contributions, sorry. So because NGOs' voices are constantly mediated, their role within the UPR can be equated to the one of a ventriloquist. Their relevance within the mechanism relies on their capacity to find a friendly mouth, able and willing to speak their words. So the Secretariat, or the drafters within the Secretariat, are really playing this role of intermediaries, trying to translate up, the claims, the right claims of these NGOs. And it's really an actor that is often overlooked in studies of the UPR, when I believe that its rather low profile enables drafters to significantly shape the content of the discussions taking place during the reviews, notably by acting as these intermediaries. But the tension between the moral duty of protecting the voices from the field and the necessity to preserve the credibility of the institution implies that drafters have to engage in myriad bureaucratic procedures whose repetitive performance serve to maintain the principles of neutrality, objectivity, and transparency. So I have argued elsewhere that, in Hilary's and Emma Larking's book, in a chapter I wrote for that book, that in spite of the tedious administrative procedures the production of document entails, their drafting involves intense discussions which are not deprived of affects and even passions at times. This observation contrasts with the tenor of the interactive dialogue, which, despite its promising name, does not provide any room for genuine interaction or debate. Such negotiation, I realized during my internship, take place off stage in the offices of the OHCHR, where drafters engage in vigorous debates over the content of a paragraph and take strategic decisions on which issues to prioritize. Since the first cycle of the UPR, the methodology used for drafting documents has changed quite dramatically. At the time of my first fieldwork in 2012, the drafting process followed an interdivisional methodology that mobilized, in fact, the knowledge and the expertise of civil servants working in the 4 divisions of the OHCHR. And in each of these divisions, there were drafters called UPR focal points, who were under the supervision of 1 coordinator, and who were in charge of gathering the information that was required for the division inputs to the compilation. And these teams of focal point worked in close collaboration with a team of drafters coordinators located within the Human Rights Council branch here, responsible for collecting all the draft and finalizing the documents. This interdivisional method had been put in place in order to avoid the personalization of documents and prevent the association of a document with one single author. This strategy was to protect anonymity, guaranteed objectivity, and enhance the bureaucratic legitimacy of the material produced. But because of their direct access to geographic desk officers who were in regular contact with OHCHR staff in the field, FOTCD drafters, here, Field Operation and Technical Cooperation Division, were responsible for the first draft of the summary of other stakeholders' information. However, the content of this document was collectively assessed during weekly team meeting and ultimately during the meeting of the country consultative group, the CCG meeting, which was an important meeting during which we took place 10 weeks before the review, and which gathered together the different drafters from the different divisions who had been involved in the production of each document, in each report. The presence of the geographic desk officers was important to validate the accuracy of the information provided in the documents. So the objectives of this meeting were to highlight contentious issues for the selected reader to decide upon, maintain a balance in the types of issues presented, ensure complementarity and consistency between the summary and the compilation, select the information that should be given in priority in the document, and it was really a strategic moment during which drafters decided on which issues emphasis had to be put. Since the beginning of the UPR, the drafting methodology has been the object of heated internal debates, especially between the managers who shared the view that it mobilized too many internal resources and it was not cost effective as a result, and the drafters who, on the contrary, defended the idea that the methodology guaranteed the quality of the information produced and strengthened the links between the different UN human rights mechanisms. But in spite of all their efforts, drafters did not succeed to convince their hierarchy. And the production of document is now following a different methodology, whereby each drafter is now in charge of the entire production of documents for 2 reviews per UPR session. The CCG meetings, the country consultative groups meetings, no longer take place, and all the focal points have been removed. Instead, each drafter is responsible for obtaining information from the other divisions. The advantage of this new methodology, according to a drafter I interviewed recently, is that it enables drafters to develop in-depth expert knowledge of the human rights situation in specific countries. However, the centralization of the drafting process has also meant that the OHCHR divisions have lost ownership of document production, and that individual drafters are personally accountable for the integrity of the information presented in each report. Furthermore, the CCG meeting were an important strategic moment when drafters collectively endorsed the content of documents and took decision on which issues to prioritize. And in this sense, these meetings had the ritual power of producing a community of international civil servants and experts bound together by principles of impartiality and transparency. So the individualization of documents production means that the UPR Secretariat is now deprived from the technical means to make community an element of its everyday work that gave meaning to drafters' otherwise highly tedious and burdensome bureaucratic task. So from keepers of the truth in the Foucauldian sense, in the sense of knowledge authorities bound to the ruler through a parasitic contract, drafters have been turned into diligent bureaucrats, able to produce documents on time and according to specific administrative rules and standards. The social dimension of their work has been partially eliminated in favor of efficiency and productivity criteria. This has meant also a loss of personal relationships between the NGOs that send their contributions and the drafters, who sometimes call them to ask whether they could, remove that paragraph or remove the name of that person so that they could take their reports on board while compiling these documents. Now there is almost an impossibility to bend the rules, at least used to be the case. So I want to conclude. Yes, I want to conclude now. So NGOs generally consider their reports successful when their recommendations are picked up by states and when those are accepted by the state under review. In the same way as the impact of scholarship is increasingly assessed according to quantitative criteria, this is to say the number of times the text is cited in other academic publications, the success of NGO's report equally relies on it being referenced in other more powerful UPR documents, this is to say in a summary of stakeholders, in states' recommendations to the state under review, in the working group report where all recommendations received by the state under review are recorded. Citation is therefore the benchmark upon which NGOs' influence is assessed. NGOs' capacity to hold the state into account primarily depends on their aptitude to convince international civil servants and diplomats that they represent a credible source of information that can be legitimately referenced. In order to be perceived as such, NGOs have to adopt the language of the powerful. They need to embrace the bureaucratic logic of the UPR, its mode of address, its diplomatic etiquette, and its specialized jargon. It also implies voicing social critique in such a way that it can be taken up by those who occupy central stage within the UPR process, that is to say, the states. In the process of participating in the UPR, NGOs gradually learn to tailor their performance according to the expectation of their audience. Their command of administrative procedures is therefore essential to guarantee their relevance in a system whose primary task is to produce paperwork and make it circulate in the world. The power of the UPR lies in its capacity to unmatch actors in its own logic. NGOs representatives engaging with the UPR find themselves caught in a double bind between their aspiration as believers in the human rights project and their duty to reach measurable goals as experts. The legal technology is mobilized by the UPR drafters in order to create documents that represent collective patterns of intention, while enlarging the field of participation also trigger an iterative process that is structured by the field itself and which ultimately tends to de-radicalize social critique. In spite of these structural constraints and the frustration they produce, NGOs increasingly engage with the UPR in the hope to have their claims voiced by others and later on translated into concrete action. But this increased participation presents limits, as the number of OHCHR drafters did not increase proportionally, meaning that modalities that could be negotiated during the first cycle are no longer negotiable as drafters are pressurized to produce quality reports and submit them according to the deadlines. Thank you.
Turn this on. Is it already on? Okay, great. I'm just going to start in. It's an immense privilege and pleasure to participate today in this conference honoring Sally Mary's work. I got to know Sally in the period 1997 to 2000, when we worked together on the Culture and Rights volume that I edited with Richard Wilson and Marie-Bénédicte Dombourg. This was the start of 20 years of sporadic but rich conversations on culture and human rights. In the noughties, we saw each other regularly at conferences and workshops, but our paths crossed more regularly from 2010 onwards, because in that year, funded by the British Academy via an application that Sally had supported as a referee, I began conducting ethnographic research with Julie in Geneva at the recently launched UPR. This gave Sally and me a whole new area to talk about. Sally's groundbreaking fieldwork at the UN on the CEDAW Committee, described in Human Rights and Gender Violence, had helped me conceptualize the UPR project in so many ways. But once I began to carry out the research, the desire to compare notes became incredibly strong. We both relished, I think, sitting together at conferences and workshops, and especially during Sally's occasional visits to Geneva, where I was living at the time, and exploring the similarities and differences between the UPR and the treaty body processes. I remember also on one occasion when Sally was in the early stages of her research on indicators and on a brief visit to Geneva, trying to track down a busy and overcommitted statistician to interview, commiserating over the particular methodological and emotional difficulties, or should I say the special challenges, of doing anthropological research in a space as transient and fragmented as the UN. As I reflect on and continue to write up the research that Julie and I conducted on the UPR, I often return to Sally's texts for ideas to help me think through the specificities of this particular human rights process. Sally's forensic delineation of the different ways that culture is understood at the United Nations remains spot on. Interestingly, I find myself increasingly grappling not with culture in its most commonly invoked sense as harmful traditional practices, as an obstacle to change, but with the culture that UN actors continue not to be able to see and that they rarely talk about, the assumptions, values, and ways of doing things that are hegemonic and unspoken, and that many, but not all of them, share. Important elements of this UN culture are particular ways of using words and numbers, ways that may once have felt strange, but have now, for UN insiders, become routine and naturalized. Sally's work has been as attentive to words and numbers in human rights processes as it has been to issues of culture, and I will be elaborating these in my chapter for this Festschrift. But today, let me focus on the issue of words, exploring it through a single ethnographic example. So in this brief presentation, I want to note a few things about the ways that NGOs organize their verbal interventions within the UPR pre-session, a new space of dialogue that was introduced in 2012 by an NGO and has now become a standard element of the UPR proceedings. Rather than expressions of vernacularization, one observes in the pre-session a strict and serious imitation of the codes used by states in the state-run UPR working group, though also a reversal of roles. Here, NGOs speak and states listen. What are the conventions of speaking here? In what linguistic forms must NGO claims be squeezed in order to be heard? Now, thankfully, Julie has already described to you the UPR, so I don't really need to do it. But let me just emphasize a few distinctive features. The review is universal. It has no experts. Rather, states are in the driving seat. And it has a non-confrontational ethos. The states, as a working group of peers, are tasked to offer constructive criticism in the form of recommendations to the state under review. So states, rather than experts, are asked to bear responsibility to encourage human rights improvement. The UPR's innovation, which we can think about through the frames of governmentality and audit culture, is to enlist states not only in self-monitoring, but now also in monitoring other states. This emergent form of human rights governance has required states to adopt new forms of speaking. No longer is it left to just a few states to thump the podium in condemnation of egregious violators or to sing praises of occasional heroes, as one still witnesses in Human Rights Council meetings. Rather, in the UPR, all states are invited to speak like a human rights respecting state, in ways that manifest the UPR principles of transparency, non-confrontation, constructiveness, and sharing of best practice. While a growing number of states have been learning to speak in these ways, the shift has not been easy or straightforward. UPR modalities and practices both enable and disable, facilitate and constrain what states say in relation to human rights within this space. And this is also true for NGOs. And as Julie has described, as in the treaty body system, NGOs cannot speak during this public audit ritual of the 3.5-hour review of the working group. But they are allowed to submit written reports, stakeholders' submissions, and these are drawn on by the Secretariat to create the summary of stakeholders' submissions. So the only moment when NGOs can publicly speak within the formal procedure is at the very end of the 4.5-year cycle at the Human Rights Plenary, which follows the working group and where the state report is formally adopted. That 1-hour session is divided equally between the state under review, the recommending states, and the NGOs, who get that 20 minutes, usually split in 2-minute segments, for them to make a kind of comment. NGOs view this invited presence during the adoption of the report as ritualistic, a moment far too late to influence anything in the collective report of the state review. So they have become very creative in identifying and making opportunities to bring their own concerns to the table much earlier in the process. And again, Julie has mentioned some of these, for example, side events, through lobbying, particularly through cultivating these individual relationships with individual diplomats and delegations, those that they have identified as being specifically sympathetic to the issues that they are promoting. The UPR pre-session was initiated in spring 2012, right at the beginning of the UPR's second cycle. It was put together by upr-info.org, the key Monitoring the Monitors NGO for this mechanism. This Geneva-based NGO, which over time has become increasingly international organization-like, continues to organize these now regular sessions. The session is held 3 to 7 weeks before the UPR session, and individuals representing diplomatic delegations, often these are interns, sometimes ambassadors, depending on the diplomatic capacity and the importance of the review, attend each country's 1-hour slot. At the pre-sessions I attended in 2013 and 2014, which were then held in a large rented meeting room of an international conference center about a half-mile from the Palais des Nations, between 20 and 37 diplomatic delegations attended, which is only about 10 to 20% of the full number. The percentages are higher now that the pre-sessions have been moved into the Palais des Nations. In 2013, UPR Info's director, the French political scientist Roland Chauville, would open each country slot by reminding those assembled of the relevant fact that, for example, the Gambia was reviewed in February 2012. It received 153 recommendations, of which 68 were accepted and 85 were noted. He would then introduce the first panel member, keep time, chair the session. In important ways, the pre-sessions mimic the state reviews, except, as I said, that NGOs speak and states listen, including the prospective state under review. So in one of the pre-sessions I attended in October 2014, NGOs from the Gambia, Angola, and Italy, as well as several Geneva-based international NGOs, shared, each country separately, a 50-minute slot on the podium to present their issues. The last few minutes of the slot are devoted to discussion, although in the sessions that I observed, it was rare for more than 1 or 2 states to ask a question, but the coffee break in between was a very crucial time for country NGOs to network and lobby. How then do NGOs speak? First, it's important to acknowledge the diversity of speakers and the vast variation in their capacities and cultural capital. The Angolan in Geneva for the first time, who spoke on behalf of a domestic violence and housing rights NGO, struggled with English and appeared generally unconfident. By contrast, the British staffer for the Geneva-based International Service for Human Rights, whose presentation focused on the Gambian government's inadequate fulfillment of its accepted recommendations, as well as the issue of human rights defenders, was articulate and to the point, although she had never been to Angola. While these variations were noticeable, reflecting the speaker's different positionalities within the linguistic and cultural hierarchies of the UN's everyday practices and their vastly differing levels of experience within the UN system, the two speakers shared a common language of description and analysis. When talking about situations in the country, they rarely talked about cultural or social specificities. Rather, they discussed issues using categories of international human rights, development, and security discourses, violence, discrimination, inadequate housing, vulnerable minorities, as well as the ubiquitous acronyms VAW, GBV, MDGs. They referred to conventions and agreements that the state had accepted, as well as voluntary commitments to ongoing campaigns, the UN Foundation's Every Woman, Every Child health initiative. Sometimes they cited a recommendation made by another UN body, especially the Human Rights Committee. NGOs regularly talked about distressing situations, yet rarely showed anger. Even when clearly frustrated or cynical, they worked hard to adopt a constructive tone. They employed a vocabulary of removing obstacles, seeking buy-in, progress made, remaining challenges, and of wishing to persuade governments to see them as partners rather than adversaries. Every presentation included a set of recommendations, not, please note, demands. NGOs formulated these in hopes that one or more of the diplomatic delegations present would take up a recommendation that they had formulated and include it in its own 2-minute statement in the upcoming interactive dialogue. For less experienced NGOs, including those who flew in for the first time to Geneva, who didn't know how things work in Geneva, recommendations could be long and unwieldy, involving 2 or 3 clauses that actually recommended several things. More experienced NGOs, or those who had been coached, often articulated recommendations that were very, very concrete, that contained a single request, making them monitorable and thus directly usable by states. This could be a literally cut and paste exercise. Many NGOs distributed 1 to 2-page handouts with 3 to 6 recommendations. And sometimes these were indeed ultimately uttered word for word as a recommendation contained within a state delegation statement on the day. In such cases, we might ask with Mikhail Bakhtin, who is speaking? When this happened, NGOs claimed ownership and authorship and used this success story in their subsequent advocacy. As this brief exploration suggests, NGO claims making at the UPR pre-sessions make manifest the simultaneously enabling and constraining character of the UPR and the UN human rights system generally. When presenting local concerns, NGOs must express them in the normative, linguistic, and conceptual categories of UN language, in the appropriate emotional registers, and conforming to the precisely designated technical parameters of speaking time and space on the page. NGOs become increasingly skilled over time in using these terms, formulations, and phrases so that those operating within the human rights system can hear them. I am so lucky to have Sally's inspiring work on culture and rights, vernacularization, mediators, indicators, and the social practices of UN meetings and committees as I continue to make sense of words, numbers, and culture at the Universal Periodic Review. But I am even more lucky to have been welcomed by her into a friendship and into the community that she has nurtured, where she's given us all the chance to take pleasure in her deep excitement about ideas, her intellectual and personal generosity, and her enormous warmth, compassion, and delightful down-to-earthness.
Okay, well, I'll just start. 15 minutes, as I see, go by very quickly. And it's always a somewhat daunting task to follow two colleagues who presented such coherent papers, so I'll do my best. So first of all, thanks to Philip for organizing this event, for inviting me to be part of it. It's a tremendous honor to be here in this capacity among so many distinguished mentors, colleagues, and indeed old friends. And I think leaving aside all the intellectual and professional contributions, which is, as you can hear, will occupy most of our time, I think it's also important to underscore what this event says about the warmth and esteem with which colleagues hold Sally, the eagerness to come together in this way from near and far. And I know this is not the first and is not the last of such events. And just on that note, I would mention that if any of you here are anthropologists and will be in Vancouver in 2 weeks, Kamari Clark and I are organizing yet another event in honor of Sally as this year's winner of the Franz Boas Award for Exemplary Service to Anthropology, which is the highest and most distinguished award offered by the American Anthropological Association. And the first winner of which in 1976 was Margaret Mead. So let me start with an anecdote. I took Philip's offer to not write a paper quite seriously, as you'll see. So what I'm going to talk about is the promise of the chapter, which will be submitted by the end of March 2020. And I want to start with an anecdote. A few years ago, there was a conference organized at the University of Michigan Law School, at which Philip Alston was also there. And this was a gathering of the sort of great and good of political philosophers of human rights. And with some legal scholars mixed in, and little old me as the one anthropologist. And it was an interesting encounter, an ethnographic encounter from my part as well. But one of the things which I tried to do at this event was to resist the insistence that I limit my contributions to the colorful ethnographic anecdotes that the political philosophers wanted me to provide so that they could then go on to do the real thinking about human rights. And it was precisely on the basis of one of Sally Mary's concepts, vernacularization, which I'll talk about, that I made these perhaps often, or at least on occasion, unwanted contributions. And so I'm very happy to have a chance to come and finally develop this idea that I'm going to present, because I was never contacted again by the organizers of the conference. And so this event will give me a chance to make this argument in greater detail. So what I want to do is summarize the argument that I'm going to make in the chapter, and then sketch out how I'm going to develop it for the volume. So first, just a bit of a refresher on the concept of vernacularization, which is just one among many of the concepts that Sally is known for in her distinguished academic career. And this concept is developed in several places, but two notable would be the 2006 American Anthropologist article, Mapping the Middle, which was a collection that sought to reframe the anthropology of human rights, and of course her book, Human Rights and Gender Violence. And so what this idea of vernacularization does is it's based on research that Sally conducted between 1999 and 2004, I would say maybe 2003, but into 2004, on the global efforts to reframe violence against women as a human rights violation. Now, vernacularization is the empirical and theoretical category that Sally develops to explore the fraught process of negotiation through which human rights ideas are put into practice. And what she explores with this concept of vernacularization is a key tension between local legitimacy or local cultural resonance in this process of translation and what we might think of as normative authenticity. And what she describes as this fine balancing act, which can't be, in a sense, theorized in a normative sense. It's something that has to be understood ethnographically in context. And I would say that for those of you who work with vernacularization, it's just something that happens with concepts that that themselves travel. is that this particular aspect of vernacularization, I think, often gets left out of the citations and the use of vernacularization, which comes to be, taken as just the process of translation. But in fact, if you go back and look at these sources, as I did to prepare for this talk, it's really this tension, this tension between maintaining a certain amount of local legitimacy, but also speaking to global or universal concerns. And some of those universal concerns are quite strategic because they get linked to funding, they get linked to NGO involvement. So this is the concept of vernacularization in kind of its pure sense. So what do I want to do with it? So what I want to do is kind of take this notion of vernacularization and, in the good Festschrift manner, expand and adapt it to apply it to a slightly different kind of argument. And that is that I think that vernacularization can be understood as a proposition for a project, a new way of understanding, a different way of understanding how human rights norms are produced, which has quite radical implications for understanding for the future of human rights. And so what I want to suggest is that vernacularization can be extended to describe the many sites where human rights are, and more importantly, should be produced, challenged, reformed, and perhaps even enforced. So to develop the explanatory value of this argument, I make reference to 3 case studies, not my own, but 3 scholars whose work has been directly influenced by the concept of vernacularization. And what I want to do is I want to show that this argument about vernacularization as a project for reframing how we understand human rights, and indeed how human rights are produced, is something that's already been present in the work of various ethnographers of human rights, if perhaps not so directly. And so very briefly, the 3 scholars whose work I'm going to be engaging with or developing is Shannon Speed's work on the Juntas de Buen Gobierno during the Zapatista rebellion against the Mexican state, which was sort of an order of chronology. Sarah Holcomb's more recent work on her efforts to work with a team to translate the Universal Declaration of Human Rights for the first time into an indigenous Australian language. And then finally, Lynette Shu's fascinating study of the place of human rights and the vernacularization process that take place among LGBT activism in Myanmar. So each of these studies contributes something different to this effort to think of vernacularization in a more expansive way as a project to reimagine the grounds of human rights. So just briefly on each of these 3 case studies. So in the case of Shannon Speed, she conducted research in this difficult period of Mexican history in which indigenous Zapatista communities were being influenced by transnational NGOs to adopt human rights as the framework for resistance against the Mexican state in order to replace the more conventional revolutionary Marxist framework, which suggested violence and which had different kinds of consequences. And what she shows in her research, and which I'm going to be developing and working with in my contribution, is how even very deeply vernacularized human rights. Now, if you know her work, you know how she shows how, in a sense, the Zapatistas pushed the boundaries of vernacularization beyond what many human rights theorists and activists would recognize as human rights. And this is going to be sort of one of my points, is that we need to sort of let go of that line about what we should be taking as human rights and not. But she shows how human rights can play an important role as a form of potentia, that is the good kind of power in the Spinozan sense, the kind of power that on occasion can be mobilized against the many forms through which sovereign violence is expressed through political economy, law, and social organization. So in these 3 different categories, I'm going to be taking Shannon Speed as an example of the way in which vernacularization reinforces the extent to which human rights can constitute a form of good power, as it were. Now, Sarah Holcomb's research, which by a wonderful coincidence was profoundly shaped by Fred Meyer's writings on various questions of Ayangu, Anango, on-the-go ethno-epistemology, and I've been practicing that word, and as you can see, I failed miserably, because it's not pronounced exactly as it's written, but revolves around the project to translate the UDHR into an Aboriginal language for the first time. Now, what her study suggests is that the quest for normative commensurability, the idea of trying to find rough equivalents for normative concepts, was itself misplaced. Instead, in a way that evokes the work on diatopical hermeneutics by the Indo-Catalan philosopher Raimon Panikkar, she argues that vernacularization should be seen as a space in which the encounters between different cognitive and moral worlds can be negotiated, yet always in relation to particular histories of domination, resistance, and social suffering. And here, as I don't have time to develop it, but the difference between topos and logos will be important for this second category of developing vernacularization. Now, the third case study that I'm going to be developing is, as I mentioned, Lynette Shua's more recent work on LGBT activists in Myanmar. And this adds a dimension to this project, to this proposal, that speaks to the question of empowerment. How is it that vernacularized human rights can become a form of empowerment for individuals and collectivities? And I think her research provides an extraordinary case study for thinking through this problem. And she conducted ethnographic research in a very, very difficult circumstances in Burmese history. So this was a time in which Aung San Suu Kyi had returned to Myanmar, and there was a sense of opening to various kinds of international and transnational developments. Researchers could go back to Myanmar. And it was also difficult in what we might call a cultural sense. So as she describes it, there was a somewhat insidious combination of what she calls Burmese karmic logic, patriarchal social hierarchy, and state suppression, which created what she calls a triple vulnerability for the Burmese LGBT community. And so her research is tracking the way in which these very hidden activists created an embryonic LGBT movement in Myanmar precisely on the basis of their embrace of human rights in the vernacular. And so this was not a mobilization against the Burmese state. This was not one which was leading to radical change, but it was one which really changed how people saw themselves and how they lived as queer Burmese. And so she in a sense gives us an extraordinary case study for thinking through these very outer margins where human rights remain important as a mechanism for empowerment. And what I want to say here is that her account teaches us that the mobilization of human rights in the vernacular, in this expansive sense, can be radical, but not necessarily revolutionary. That human rights can become a framework through which individual and collective empowerment is expressed, and as important, experienced. And in her account, she focuses at length on what we might think of as the phenomenological dimensions of empowerment, as opposed to their institutional, or even social dimensions. And she carves out a space for this phenomenological dimension as an important way of understanding the potential for vernacularized human rights. And as she puts it, this is at the end of her study, out of human rights, LGBT activists in Myanmar fashioned a way of living more authentically as queer people. Okay, so after developing this through these various case studies, the notion of vernacularization as a project for regrounding human rights that is expansive and indeed subversive in relation to orthodox understandings, I then step back in the chapter, I will be stepping back in the chapter, and using this concept of vernacularization to consider debates that are now raging about the future of human rights. And so many of you who are human rights scholars know those kind of debates that I'm referring to. And instead of the do they work or don't they work angle, which tends to occupy a part of these debates, or the question of ongoing global legitimacy, what I'm going to argue is that vernacularization offers a quite different response to the question of the future of human rights, which is to show how human rights might be reframed or regrounded as a translocal, though not universal, logic that harnesses human rights potential for power and potentia in the Spinozan sense, this diatopical understanding, which is an encounter between different cognitive and moral worlds, and empowerment. So finally, why do I describe this account of vernacularization as an anthropological ethics? And this brings me back to the University of Michigan conference, and perhaps explains why I was never contacted again. And that is, I think to privilege the practice of human rights, as Sally has done in her work, and to insist on the practice of human rights as a fundamental basis for understanding human rights, for what they can be, what they are, their limitations, is also to make an ethical claim about the importance of decolonizing human rights through cultural pluralism and normative contingency, which also carries implications for the sites and the people who inhabit those sites where dominant ideas about human rights have traditionally been produced and debated. Thank you.
I want to first thank Philip Alston for convening us and for being such a gracious host. It's a pleasure and an honor to be here in this stellar panel. In many walks of life, people want to have the last word, but in academia, we know better. We prefer instead to have the first word. Being among the first people to explore a topic is among the surest ways to attain prominence in academia. But you have to have a keen sense for which under-explored topics are explorable and worth exploring. Sally Mary has this knack for letting her intuition roam across her broad reading until she finds a direction for research that other researchers will want to follow. In a career made up of pioneering research engagements, one for which Sally has gained most recognition perhaps, is the study of indicators, indexes, and quantification in social justice reporting and international governance. In this area, Sally's work has certainly had a productive influence on my research. Currently, my main area of research interest is the visual and verbal rhetorics of the new abolitionism. Sally's work specifically makes it easier for me to move beyond debunking weakly substantiated prevalence estimates to consider also what she succinctly calls the knowledge effects and governance effects of quantification. My question is, how do prevalence estimates make knowledge effects felt within textual and visual expositions of the wrong of human trafficking and modern slavery? I'm convinced that valuable answers to this question are to be found by moving away from evidence-based reasoning and into a critical vocabulary of feeling, noted in literary and visual culture studies. My information sources are the websites of some of the world's leading anti-trafficking and anti-slavery non-governmental organizations, to which I give particularly close attention at those pages that explain what counts as trafficking and slavery and what does not. Critics of anti-trafficking may miss the mark when they simply debunk trafficking prevalence estimates as fabrications. What these critics of anti-trafficking miss is how intuitions and emotions and the imagination may persuade people to support anti-trafficking efforts even in the absence of much evidence. Even as many consumers of anti-trafficking messages may accept these numbers at face value, comparable numbers of other consumers can be credited with seeing them for what they are, best guesses. In pondering how both the credulous and the skeptical may be convinced that human trafficking is a vast but hidden epidemic, the knowledge effects of quantification that interest me include not just false certainty, but also tacit admissions of uncertainty and the rhetorical positioning of not knowing, not as a reason to hesitate, but as a reason to act. In this, I find help from an unexpected quarter. Karl Ove Knausgaard's essay, Vanishing Point, published in the 17 November 2015 issue of The New Yorker. Knausgaard, excuse me, Knausgaard ruminates on the expression of feeling triggered globally by the now iconic photo of the body of Alan Kurdi, a tiny Syrian boy found washed up dead on a Turkish beach. He identifies this photograph's incidence into global awareness as a rare occasion in which media coverage of the Syria crisis shed its emotional remoteness in favor of something particular, singular, and unique. The photograph of Alan Kurdi forced upon its viewers the realization that not just masses, but people were dying. Knausgaard writes, while this insight may be banal, its repercussions are not. He adds this, and I'm just going to let you read it yourself because I'm confident you can read it 5 times faster, approximately, than I can read it out to you. With apologies to people at the front of the room, maybe I should read it.
No, that's you're good.
No? Okay. So the instant a novel is open and a reader begins to read, the remoteness disappears. A lot could be said about the relationship between fiction and social justice mobilization, to which Knausgaard points, but that's not where I want to go. While the epistemological frontier between personal narrative and quantitative and paradigmatic ways of knowing is exactly what interests me, I disagree with Knausgaard's premise that the novel uniquely possesses the power to cross and recross that boundary. Rather, I see vanishing points being crossed and recrossed in a lot of social justice reporting and public appeals. In the anti-trafficking literature specifically, quantification often pops up at the vanishing point where the personal narrative of a survivor or a rescuer segues into didactic modes of exposition. This common practice of juxtaposing prevalence estimates with personal narratives tacitly positions the survivor story as one instance of a much larger problem. This story of the rescue of an underage Filipina sex worker named Kim begins with a narrative of entrapment. A kind neighbor, AJ, inveigles himself into Kim's life, paying for her schooling out of seeming benevolence, until he betrays Kim's trust through an act of sexual exploitation. AJ's abuse escalates as he poses Kim naked in front of a webcam and subjects her to sexual abuse. The narrative culminates with Kim's rescue and AJ's arrest. A prevalence estimate enters near the end of this story as a kind of denouement. Thousands of children are being exploited online today in the Philippines because people like AJ have absolutely no fear of being held accountable. Whether the geographic scale then is national or global, personal narratives often abut directly with prevalence estimates or some other kind of view from 30,000 feet. The prevalence estimate is not something known with any certainty, but is unknown, or at best unproven, a quantity that can only be guessed at and is quite possibly unknowable. Knowing for sure how many Filipino children are being exploited matters less than knowing that thousands might possibly be being exploited, like Kim. Thousands might therefore be called a subjunctive number, a figure that stands in plausibly for what we would be likely to find if only we could know. In chapters 5 and 6 of The Seductions of Quantification, Sally Mary anticipates how the impersonal number often intertwines with the personal narrative. Sally describes, for example, how in 2000 the Trafficking Victims Protection Act was pitched to members of the United States Congress through, I quote, horror stories about the treatment of victims, combined with huge estimates of the number of victims, end quote. In like manner, Sally writes about the distortions inherent in making the face of trafficking, quote, a young girl, usually poor and brown, who has been kidnapped and passed from hand to hand until she ends up in a brothel in a large city, end quote. Sally was not the first to draw attention to this frequent juxtaposition of personal narratives with prevalence estimates in the anti-trafficking literature. The major shift that she signals instead is to switch the focus of anti-trafficking from the reliability of numbers to the knowledge effects of quantification. That's okay. I once got my phone once went off and I was giving it.
That was Sally, though. So
No,
that's
no.
okay.
While I was
person,
giving a
it's okay.
talk at the University of Chicago anthropology department. Oh dear, yes. Whether numbers are reliable, so I sympathize completely. Whether numbers are reliable or not matters, but it also matters whether the numbers are believed or not, and what effect they have on the thinking of consumers of social justice reporting. The segue from a personal story to a prevalence estimate is not the only way vanishing points are made. At other moments, the vanishing point is entirely visual. Here's the banner image on the Polaris Project's 2019 webpage on human trafficking. This image and its accompanying text convey a mixed message. The words speak with certainty. They declare, describe, and quantify what human trafficking is. The image, by contrast, evokes the shadows in which trafficking is said to thrive. Text and image together visually confirm that human trafficking is a vast but hidden wrong, the unperceived presence and unknown dimensions of which compel us to act in spite of limited knowledge. By merging a voice of clarity and certainty with an image of occlusion and uncertainty, this webpage from one of the oldest and best networked anti-trafficking organizations conveys something fundamental about the new abolitionism. Faced with the criticism that human trafficking has been constructed as a global concern in the face of a lack of verifiable data, new abolitionists have on one hand promised that more reliable numbers are on their way, while on the other hand, artfully embracing uncertainty. It is less a matter of evidence than of belief. If you believe, then even failing to get evidence of captive exploitation is to be taken as evidence of how deeply hidden the crimes are. A first larger point, then, is that if quantification seduces in the new abolitionist field, that happens not through numbers alone, but through image textual amalgams, where prevalence estimates are juxtaposed with personal narratives, didactic text, and evocative photography. A second point is that vanishing points are expository constructs and not products of unavoidable gaps in knowledge. In another possible anti-trafficking world, information might fill the expository space where prevalence estimates now reside. Whether through habit, uncritical acceptance that trafficking is a hidden wrong, a preference for simplicity, or an actual aesthetic preference for the shadow over the figure. Prevalence estimates are preferred over the detailed qualitative studies that, to quote Sally Mary, would be essential for understanding trafficking in all its variation and complexity. But instead of providing qualitative case study findings, new abolitionists do not just stick with prevalence estimates, but double down on their importance by saying over and again that more reliable estimates are needed. If quantification is productive, then, the first thing it produces for the new abolitionism may not be false certainty so much as a jaundiced acceptance of ignorance. Big round numbers convey tacitly that not knowing is inevitable, and that uncertainty is the natural condition of anti-slavery activism today. It is of paramount importance, as Sally Mary gives emphasis, not just to question the reliability of numbers, but to examine their knowledge effects, among which I include intuitions, emotion, and the imagination. As one of a small handful of people who have said important first words on the seductions of quantification, Sally has helped me along a road of discovery that may be long and circuitous, but promises to be worth following to its end. Thank you, Sally.
Blankets my own file here. Is there anybody more familiar with Thank you, Philip. I've been a fan of Sally's work long before it was articulated in relation to human rights. I followed her traverse from the anthropological study of disputes to broader concerns with justice and the relationship between international frameworks and the messy cultural realities of local conditions. As New Yorkers know, it's all about location, location, location. And I should add, our offices are adjacent. Let's see. In the early 1970s, when I was first doing field work with remote living Indigenous Australians, I can remember walking in the streets of the town of Alice Springs in Central Australia, then a little town of about 10,000 people. While I had become friendly with many Pintabee people living in distant communities such as Yai Yai, where was my principal field site, I didn't know at the time many people in Alice Springs. I was surprised to be approached by a somewhat bedraggled-looking, slight, middle-aged Aboriginal man. He told me his name was Chalamu Chabangardi, and he was the cousin of my friend at Yai Yai, Ginger. Chalamu was part of an early wave of Indigenous people who had moved east from the desert. His mother was a Pintabee woman who had married an eminent Indigenous evangelist, Titus Rambaraka, from the Aranda community. Could I help him, he asked. He had recorded, I would say shared, some songs for the famous anthropologist Charles Mountford, who had made several trips through Central Australia in the 30s, 40s, and 50s. I say shared to emphasize he would have understood this as keeping while giving, as Annette Weiner called it, not a complete alienation of his rights. These songs, he told me, were men's business, based on important gender-exclusive initiation ceremonies. I already knew that the revealing of such music or ceremony to non-initiated persons, particularly women and children, was said to be punishable by death. As a man who knew their language and had been given a position in the kinship system, I'd been allowed to hear the songs, but I'd also been told, more than once, of this punishment and stories about when it had been carried out. Chabangardi looked truly miserable, incredibly anxious, even to the eyes of an inexperienced 25-year-old American. I was flustered. I had no idea what I could do. I didn't know Mountford, or even whether this record actually existed or was simply a rumor. The only recourse I could suggest was to go to the recently established Aboriginal Legal Aid Services in Alice Springs. I'm going to hold back on that one a minute then, okay. I don't think I ever saw Talamu again, and I don't know what happened. I'm not sure there was a record in the end. I haven't been able to find it, and that's probably fortunate for him. My encounter with Talamu is exemplary of those times, the 1970s, when concerns about the publication of Aboriginal restricted cultural material or the appropriation of sacred designs was reaching into the life worlds of remote Indigenous Australian, in part due to changes in the technologies of recording and circulation. These were not the civil rights for which protests dominated the 1960s, and they represent a change that is also expressed in the Aboriginal Tent Embassy set up in Parliament House lawn in 1970. If you've never seen what this looked like, it was a brilliant kind of performance art, really, in which they took up residence in the Parliament House lawn, which they had the rights to by virtue of regulations in the city, and they established themselves as an embassy, a sovereign nation. I want to tell a few stories about these matters of cultural property and how they came to be addressed. I regard the incidents as important in several ways, especially in the context of Sally's work on the vernacularization of human rights and the subsequent developments of the UN Declaration of Indigenous Rights and later of Intangible Heritage. They didn't exist. I want to underscore how Indigenous concerns for control over their cultural materials came to find some redress in the Australian legal system, perhaps triangulating between the locally legitimate forms, Australian legal systems, and the imagined more international imaginings of justice. This is after World War II. It's a time when Australia is under some kind of attention. This is a case, broadly, that is grounded in what we now know as the UN Declaration on the Rights of Indigenous Peoples, passed in 2007. Article 31, which you probably all know better than I do, it provides for cultural rights. It reads, these are out of order. This was, just to give you the early 1970s, the Aboriginal Legal Aid. This is a book that was published, oral history with the lawyers from Melbourne who came to work in Alice Springs to encounter a sort of colonial world, but also a set of cultural understandings on the part of Aboriginal people and practices that were very different. This is a photograph of the hearing of a large number of people. The magistrate would fly out on a plane every month or two, and they would line up all the people who had warrants for them, and they would be processed within an hour, okay? Anyway, the article reads, Indigenous peoples have the right to maintain, control, protect, and develop their cultural heritage, traditional knowledge, and traditional cultural expressions, as well as the manifestations of their sciences, technologies, and cultures, including human and genetic resources, seeds, medicines, knowledge of the properties of flora and fauna, oral traditions, literatures, design, sports, and traditional games, and visual and performing arts. They also have the right to maintain, control, protect, and develop their intellectual property over such cultural heritage, traditional knowledge, and traditional cultural expression. Australia has never signed this. Anyway, it did not exist as the rights of Indigenous people, like the other settler societies have tended not to do that. It didn't exist certainly as even a platform of rights in Alice Springs in the 1970s, nor has the government even now signed. But a sense of a moral right had emerged regarding cultural rights or wrongs for Indigenous cultural property. And these found their way into Australia's legal world, most notably in relationship to intellectual property and copyright. Anglo-Australian legal categories were expanded to take on the work of seeking redress for Indigenous claims of wrongdoing and harm, both inside and outside of formal legal processes. In 2006, Justice John Van Dusa spoke to issues of Indigenous cultural and intellectual property, summing up this history, to an international conference explaining their significance in relation to concerns over the theft and appropriation of imagery and design from Indigenous art in a lucrative and growing high art market. The Aboriginal art market, he said, I'm going to quote from him, is presently estimated to be worth about $200 million a year. Along with this, demand has grown. The need to respect and protect Aboriginal cultural ownership of images and spiritual stories embedded in the works, especially against unauthorized copying and misuse, has led to litigation which has explored the application of principles of the common law and statutory-based protections in the Australian legal system. The concepts underlying these principles, he maintains, are not unique to Australia. The principles of equity that protect confidential information and fiduciary obligations are well known and widely applied. The statutory regime for the protection and exploitation of intellectual property reflect international conventions. What is interesting is how these principles have been applied in the novel context of Australian Indigenous traditional laws and customs. No doubt mine was not the first suggestion to an Aboriginal complainant to seek help from legal aid, but that institution wasn't even available before 1972. As an aside that perhaps explains the moment of legal development that existed in Central Australia, one of the legal aid lawyers in his oral history remembers attending a screening of a Western cowboy and Indian movie at a remote Indigenous community in which the cowboys, either the cowboys or the cavalry, were winning when one of the Aboriginal spectators stood up and shouted, "Call in legal aid." Sally Mary's work as she moved from the framework of legal disputing to human rights helped me to see these interventions for Indigenous Australians as part of the post-World War II embrace of human rights, which had shaped Australia's policies regarding the treatment of the Indigenous people there. And in a film that was made about the Tent Embassy in 1972 called Ningalana, this is how they started the film with a series of basically statements. This is the third of them, articulating Amnesty International's report on Australia and its failures to address the issues with Indigenous people, so that the Tent Embassy itself was understood to be, in some sense, articulating a claim based on these rights, although it wasn't necessarily understood that way in Central Australia. But nonetheless, cultural rights had not entered seriously into discussion, but the wrongs or perceived injurious experiences were increasingly demanding response. So let me give briefly two examples of disputes over what might be called cultural rights that I encountered in the 70s. One prominent example with far-reaching effects for Western desert people was the banning of Richard Gould's book Yawara at Warburton Range Mission for revealing photographs of secret men's ceremonies. Gould, who was at the time a curator at the American Museum of Natural History, location is everything, had taken photographs of many ceremonies and promised that these would not be seen in Australia. Of course, despite such impossible promises, the book found its way to Australia and into the hands of a young Ngarrindjatjara woman who was at school in a nearby town. Women were forbidden to access to such knowledge, and the custodians of this knowledge threatened to spear her in punishment for looking at the photos and possibly to kill Gould. The scandal occurred in 1971, and by 1973 had significantly affected the conditions under which I was allowed to visit ceremonies, no notes, no camera. And through it, I understood Chalamu's predicament. A second significant event was the litigation brought by the Pitjantjatjara people against Mountford's classic book, Nomads of the Western Desert, which was published in 1976. This book contained details and pictures of secret ceremonies of Pitjantjatjara men, details provided to Mountford some 35 years earlier during a research trip. The litigation was undertaken to prevent publication of the book in the Northern Territory where the people who were photographed lived. The injunction was granted as the plaintiffs, this is according to Van Dusa, sued on their own behalf as individuals threatened with damage of a cultural kind. They argued that the revelations of the secrets contained in the book to the women, children, and uninitiated men may undermine the social and religious stability of their hard-pressed community. It was basically decided on the basis of confidentiality, and it was prevented from being used in the Northern Territory. However, very suddenly a fire occurred in the warehouse, thereby saving the publishers the possible cost of destroying the books. They would be reimbursed. The question of how to recognize claims over the display, performance, and circulation of culture have become a significant concern with Indigenous people. Before these questions of cultural politics had gained academic focus, as we know, they had considerable visibility in these Indigenous communities in the Anglo-settler nations. From early on, however, it seems to me that the Indigenous communities in Australia have struggled with the subordination of their own law, which they call law with a capital L in English, to that of the Australian nation-state, more than frequently insisting on the equality of the two laws, bewildered by the fault lines of the Australian legal regime, which can threaten to chip away at the sovereignty of the very protocols it appears to protect. In the adjustments around cultural property in Aotearoa, New Zealand, the Maori protocols have a standing that Indigenous claims lack in Australia. In the triangulation that Von Dusa celebrated, there is still a gap in the articulation of cultural rights. There's protection, but no recognition of cultural rights more generally in Australia. If the conventions on human rights have been difficult to translate linguistically, as Sarah Holcomb has shown, and linguistically and conceptually, the moral assertions of control over cultural property has continued unabated. And anthropologists like myself are indebted to Sally Mary for offering us ways of considering how laws and rights have extended into Indigenous communities and the complexities of this interpenetration.